Good morning, good afternoon, ladies and gentlemen, depending on where you're at. I'm Roy Rossini with OITVOIP, and here we are for the last Partner First of 2020. It seems like this year has flown by. It's been exciting and very fun, very wild ride, but we're very excited to be here. So today I'm very proud to have with us not one, but two attorneys that are going to talk to us about probably one of the most oft conversed, discussed, and confusing additions in 2020. That is BAUM'S Act and Kari's Law and how it affects us VoIP providers. So I'm very proud to introduce first Christine McLaughlin. Did I pronounce that correctly?
Yes, you did. Thank you, Ray.
Okay, thank you. Christine is not only an attorney at, she's senior managing attorney at CommLaw, but also I see several publications under your CV. Christine, why don't you tell us a little about yourself?
Well, my name is Chris McLaughlin. I am a newcomer to the CommLaw group, but not to communications law. I've been practicing in various aspects of the industry for more than 20 years, and including some voice over IP, a little bit of traditional telephony, wireless, and media work.
Awesome. And Mr. Michael Donahue, partner at CommLaw, and literally wrote not one, but multiple books on telecommunications. Michael, why don't you tell us about yourself, sir?
Thanks for having us today. As you said, I'm a partner at Marashling and Donahue, the CommLaw Group. We are a boutique firm that focuses on and specializes in representing technology and telecommunications companies in regulatory, legal, tax, those kinds of issues. I have been practicing representing telecommunications companies for close to 25 years now. So these are the kinds of issues that we deal with customers and clients on a daily basis.
And it seems telecommunications specifically changes every chance you look, right? The FCC changes stuff, the White House changes stuff, and it's just, forget trying to keep up with the technology, just the different laws and keeping track of compliance is, it's a big ball of wax, and that's exactly where you guys come in. Not only handling the compliance side as far as registration and remittance and all that stuff on the accounting side, but you guys are a little special in that you do accounting and law. Is that correct?
Right.
Yeah, it's awesome. So without much further ado, like I said, it's these two items have been often discussed in the telecommunications world, very confusing to a lot of us. We specifically left this till the end of the year to discuss it because we wanted to get the final word on everything that we are going to expect in 2021. So I'll go ahead and put your presentation up, Michael, and you can take it from there. And as we go, guys, you know how it goes. Go ahead and add to the chat. We will answer questions as they come along. We'll leave some for the end, but this is for you. We have good representation. We've been working with CommLaw Group for a long time, but we want you to get your questions answered so you can be best protected as well. Michael, go ahead and take it away, man.
Great, thank you.
I think we lost your lost your presentation there.
So once again, thanks for giving us this opportunity to talk on this issue. And as you said, these two laws, I think, are representative of the, I hate to say it, lack of clarity and confusion that FCC rules can implement. So hopefully we can provide some clarity and help out your listeners today. So there's two interlinked laws that went into effect this year that create new legal obligations and expand obligations for specialized telecommunications providers. The purpose of these new laws, Kari's Law and Section 506 of the BAUM'S Act, is to offer better 911 access and emergency responses to callers in need. So throughout the presentation, we're going to refer to Kari's Law and BAUM'S Act. We're referring to both the actual statute and the FCC's implementing regulations. And it's the FCC's regulations is where a lot of the detail and a lot of the the confusion comes in. So Kari's Law targets enterprise communications providers and business customers, guaranteeing that all 911 calls made, no matter what kind of system or what kind of technology, will connect to an emergency responder without further action by the user. The BAUM'S Act brings non-standard providers, including voice over IP providers and virtual carriers, into line with the 911 access that and duties and rules that have long bound traditional wireline services. The BAUM'S Act also increases the level of location detail that service providers must provide with a 911 call. So we'll explore the scope of these new rules, the type of companies that are affected by them, and the compliance measures that a company can take to address these requirements. Before we move on, I do want to do just one of the obligatory legal disclosures or disclaimers that while we're doing this to provide information, it's not intended to provide legal advice or to replace the advice of counsel. So if anyone has questions, we recommend that they refer to their counsel or seek advice from a lawyer. So Kari's Law, if you may or may not know, came about as a result of a tragic incident that revealed a glaring shortfall in the existing multi-line telephone systems used by many businesses, in particular hotels. And that is that it's necessary to dial out of a system to reach 911 or to make a call by first dialing a 9 or an 011 or some other digits to get out of a call, which can create delay. So the heart of Kari's Law is a simple mandate to deal with and address this flaw. All business telephone systems must connect directly to 911 without any additional action required by the caller. So no further action, as the FCC clarified, means no additional button presses, no spoken phrases, no passcodes, nothing else but just dialing 911. Business phone systems must place no hindrance between their users and rescue services. Secondly, under Kari's Law, all 911 calls must trigger a notification that goes to a central location, alerting them that a 911 call has been made, providing the location of the caller, and any additional information that they can present to the central location. Kari's Law and BAUM'S Act, and in particular the FCC's rules, impose different burdens on different parties depending on where they are in the communications ecosystem. Because both of these laws and the rules impose different obligations on an entity depending on where what role it's playing in a particular deployment, it's especially important that companies look in each deployment, in each situation, as to what their role is and the scope of their obligations. This is especially important where multiple entities are involved. For example, if you have a situation where one company installs a system, another manages it, and the third party provides SIP trunking for connectivity, it may not be clear which entity has what obligations or what the scope of the obligations are for each provider.
So if I can ask real quick, Michael, so the previous slide you had there that, they need to be unencumbered when trying to access 911 services.
Right.
That's to prevent, those old legacy systems that you had to dial 9 before dialing a number. The expectations, you just dial 911, you get to the emergency services, right? Without any, okay. So has there been any clarification on where that differentiation and burden lies between the service provider, the PBX provider, any on-site maintenance personnel? Has there been written clear guidance on that?
Other than the guidance that's in the rules themselves, no. And so the rules place obligations on categories of, and actually here, they place obligations on different categories of providers or classes of providers. They place obligations on installers, manufacturers, and sellers or lessors of MLTS systems, and they place different obligations on the operators and managers of those systems. So it may not be clear, and the obligations are clear as to what each of these classes of providers have to do, but what may not be clear in a particular deployment or a particular instance is, am I a seller of a system? Am I an installer of a system? And am I an operator, or am I all of those? And what does that mean for my obligations? So And it's not always straightforward. An entity could be both an installer, it could be a manufacturer or a manager, and depending on the configuration, it may share some of the obligations with other providers. At a high level, and this is where the details are in terms of where for each class, manufacturers who design systems are required to ensure that their systems come pre-configured or out of the box with the capability, if installed correctly, to enable direct dialing of 911 and to enable dispatchable location. The FCC does point out that while the default must be direct dialing, systems can include the option of additional dialing patterns if a customer wants it, but the preference is that those don't exist, that it's direct dialing only. And on the other hand, the installers, managers of systems have to ensure that when they're installed, that they're properly configured so that they do provide direct dialing 911 and that they provide the central notification and dispatchable location information.
Who's ultimately responsible for determining what role you fall on if it's ever in contest? Is that something the court would decide on a case-by-case basis?
Yes, potentially. And we'll touch on a little bit later. The FCC determined that if there's a failure in compliance, that it will first presume that the manager of a system is responsible. And the obligation will then be on the manager of the system to show that it was in compliance and it was some other provider or some other situation that resulted in the failure of the system. So
I think that's an important fact, because regardless of where you lie here, it's manager first, right? You get the first burden.
Exactly.
Yeah.
Right. Especially, yes, because that's, again, depending on the scenario, there could be multiple entities that have some role in managing a system, and that's where the FCC will look first if there's been a failure in a system. So in addition to direct dialing, Kari's law requires that a system provide central notification to a central location, and that location can be worked out with a customer. It can be a front desk of a hotel, for example. It can be a security office or another central location that the customer and the provider work out. The notice must be provided at the same time as a 911 call, so there's no delay. The notice goes to the PSAP at the same time that it goes to the central location. And it has to include, at a minimum, certain kinds of information. It needs to include, first off, the fact that a 911 call has been made, that this is an emergency call. Then it has to provide a valid callback number. And then it has to also include information about the caller's location that the system conveys to the PSAP so that the information is the same. So if first responders show up and they say, we're looking for Suite 301, Building East, the central notification has that same information so they can direct first responders. Depending on
how the notification needs to be placed, is email allowed? Is it a phone call with pre-recorded greeting?
Yes, and it can be a message, a text message. It can be a phone call to one or multiple numbers. It can be emails. The FCC didn't specify exactly what the central notification needs to be. Again, it wanted to provide flexibility to customers and to their providers to work out what makes the most sense for each customer and their circumstances.
Gotcha. Okay.
And so one factor that what is a callback number and what does that mean? That sometimes comes up, and again, depending on the configuration and what a customer wants and what their systems are like and what their needs are, it can be the caller's number. It can be the direct number of the person who made the call. But it doesn't necessarily have to be depending on the configuration. It can also be an internal extension, or it can be, again, the number of the central location, a security office or a front desk that can then track down where the call originated.
So, and that's been a matter of contention, right? Because this most notably comes up with, like, most of our partners, our resellers are asking, okay, well, what about schools? What about churches? What about, college campuses, right? Where you may have 200 doors inside a physical building. Previously we would do it per floor level. or something like that. How granular does this have to get?
So from the FCC standpoint, again, they didn't define exactly what it needs to include. It needs to include a validated address and then any additional information that would help first responders reach the caller. And they wanted to provide flexibility again. So on a large campus, you may need to have more information about a building or a lab in the basement or a floor and a suite number. In a smaller location, then maybe that level of detail isn't necessary. Just a floor and a suite is sufficient. I will say that the FCC is a floor, and there are requirements in states that are potentially more onerous, and in some cases they determine the level of detail based on the size of the location. If it's a certain amount of square feet, then the information has to be within a quadrant of a building. If it's larger, then it has to be a more detailed location. So the FCC sort of sets a floor and provides some flexibility, but states may impose different or more onerous information requirements.
Have you seen any states expand on that yet? That they've started to create their own?
Not yet. There are a number of states that had laws in place already that require some level of information, primarily for multi-line telephone systems. What the FCC did is it expanded the dispatchable location, that additional information detail, to other types of services, to voice over IP, to outbound voice, one-way only voice, to non-fixed voice over IP. So services that weren't already included by, for example, a state law, the FCC expanded to include that. I'm not aware of states expanding their statutes to match the FCC yet, but particularly in states that are more actively involved in these kinds of things, that's a possibility.
Interesting. We have a question here from Alan Miller, because you mentioned multi-line telephone system operators shall monitor and respond appropriately to all 911 calls made on their systems. What if they don't have a 24/7 central location, right? So we send the email out to what would be their receptionist or whoever their person is, but that person's not working. They're a normal 8x5. Maybe a maintenance person after hours. I'm hypothetical here, but maintenance person working after hours dials 911. The notification goes out to who would be the receptionist, but that person's not there because they're off hours.
Right.
I know we're getting into the weeds here, but is there any guidance on that? I mean, how liable is the person that owns the system, the building owner? And
Right.
I know I'm asking a lot here of how liable a hypothetical court may rule, but realistically, what are the reasonable expectations of a business like that?
Right. So there's the intent is that the notification will go where it's likely to be seen and monitored. But again, companies can work with our customers to determine maybe it needs to go to multiple phones, maybe it needs to go to multiple locations in multiple formats to ensure that if there's no one tending that desk, that it'll go into an email to an office manager, or it will go to a text message to the security chief or something similar. So the FCC wanted to provide flexibility, but recognized that there may be instances when it's not monitored, and that's beyond the provider's control. In some cases, it's really that's the enterprise or the business or the college campus where the system is deployed. But the intent is that it goes where it's likely to be seen. It doesn't have to be, but that the intent is that someone will get this information and be able to help first responders reach the caller.
Gotcha. Okay.
And so we just talked about a little bit. This is the central notification is this is the definition the FCC has. It's basically a feature that sends notice to a central location at the facility where it's deployed. The details about what it needs to include. As we talked about, it can be an on-screen message on someone's computer. It can be an alarm that flashes or beeps on a handset. It can be text messages to an administrator or to a security office. And again, it's someplace where it's likely to be seen, and that someone can see it and respond to it. But again, the FCC recognizes that may not be the case in every instance, as long as it's designed so that it's there's a good chance someone will see it and be able to respond.
Gotcha. And real quick, because I realize we use the term operator, but I don't think we defined operator. Is operator the one maintaining the PBX, or is operator the end user using the PBX that owns the system? I.e. the business owner. Who qualifies as operator in that definition?
Sure. So, and I'll touch upon this a little bit. The operator is essentially the entity or the organization that's doing the day-to-day operation of the system. In most instances, that would be the enterprise customer, but not always. And there may be an operator of the system who directs an installer or a manager to take certain actions. And the definitions talk about who determines what steps are taken, who controls what steps are taken. That's who's managing the system. So again, depending on the circumstances, if something's installed and you have a management contract with a solution that's installed, the enterprise is potentially the operator because they're the ones operating that system on a day-to-day basis. The company that installed it and has a management contract to perform certain functions, are they managing? Are they providing those functions at the direction or control of the operator? There's some, the definitions describe who's what, but there are some areas where it may not be clear exactly what role a company is playing. And that's sort of, the Kari's Law divides obligations into two categories. One is for manufacturers, sellers, and lessors. The other is installers, operators, and managers. And the FCC, so for example, the installer is the entity that configures the system or performs other tasks to get the system ready to operate. These tasks may include tasks such as establishing the dialing pattern for emergency calls, determining how calls will route to the PSTN, and configuring or determining the interface to the PSTN. So that's the installer. Manager is responsible for overseeing, controlling or overseeing the MLTS after installation. May be the same as the installer, but it's a different defined role. And those responsibilities can include determining how lines should be distributed, including adding or moving lines, assigning and reassigning telephone numbers, and ongoing network configuration. So again, the definition says responsible for determining how something is done. That may not be the entity with the management contract because they're just implementing a change that was determined by the operator.
Gotcha.
And then an operator is the entity responsible for the day-to-day operations of the system. Most service providers will fall into the installer or manager role, but not always. So the role is determined by the exact functions that an entity provides in that installation or that deployment, and it may be different from one to the other. So determining where a company fits is very important because of the way the obligations fall. And as we said, the manager is presumed to be liable if there's a failure in the system. So if a company falls in that role, then it wants to ensure it has done everything it can to make sure the system is compliant.
It strikes me that there's a play here for hosted providers who have more direct control of the entire ecosystem, because they can go in and they can say, because there's so much, the onus is on, like you said, the manager, the operator. As a hosted solution, you can come in and say, look, we know we're in compliance with this, and there's no finger pointing because we can make sure that we are all the parties involved. It's us and the enterprise.
Right.
So we can make sure that everybody's adhering to the laws that are appropriate. So those voice providers out there listening, that seems to me, versus having the on-prem PBX and then the separate phone company providing the line and the separate person doing the maintenance and whatever else, the hosted providers are in a really good spot here.
Yes, absolutely, because they control it all, and it's clear in some ways, both in terms of who has responsibility and liability, but also who can control it. If you, as you said, if you have multiple providers, who is responsible for 911 compliance, and what are their responsibilities, and do they need the assistance or cooperation of one or more of the other parties that are involved? And it certainly complicates what's already not entirely clear law and rules.
I see a question here from one of our resellers. I know you have here when it goes into effect. I know the different laws, or I understand the different laws have have different application dates. How does this affect the legacy phone systems, ones that were installed prior to these?
So that is a good system, a good question. So in the MLTS context, it's the FCC's intent is fairly clear, but there are some nuances. The intent was that anything deployed, already installed and deployed prior to February 16th of this year does not need to be retrofitted or upgraded to comply with either the direct dial 911 or the dispatchable location requirements. So, anything that's sold, leased, or installed after February 16th, even if it was in a warehouse prior to the 16th, if it's installed after the 16th, it has to comply. So the intent is that anything that's already deployed and already in place from an MLTS standpoint is grandfathered for the Kari's Law and dispatchable location requirements. Where there's, the FCC applied that to MLTS systems, but what about voice over IP systems? There is no grandfathering for a voice over IP solution that's deployed prior to February 16th. It must come into compliance with the dispatchable location requirements by the 2021 or 2022, regardless. So certain legacy systems are excluded, and I'll get into here a second. There are some exceptions to that if a system is upgraded or modified in a way that is significant enough to essentially make it a new system, then all of the requirements are triggered and come into place.
That's perfectly clear as mud. It seems like
absolutely.
Did they purposely, I know it's not your fault. Did they purposely? Was there any communication when these two laws went into effect with how it would affect the service providers? Because I'm thinking of the technology standpoint. When you say VoIP, I mean the VoIP. There's not one. There's dozens of RFCs that qualify as VoIP. You know what I mean? I have Samsung, OS 900 systems from 10, 15 years ago that used MGCP and H323 and SIP. So they're VoIP, but I would consider it as a service provider, I consider it a legacy system. So what defines what VoIP is, right? Is it hosted only? Is it on-premise using VoIP technology? Where does that line lie?
See, and unfortunately, it's not clear. The context was deployed on-premise systems, I think, from the FCC. The FCC did seek comment, and parties did comment, and the FCC made some changes to its rules based on those comments. But from the discussion and the FCC's determination, it seems that the intent is that infrastructure that's already in place prior to the implementation of this law that cannot be modified without substantial cost, either to the provider or to the customer, don't need to come into compliance. The FCC, though, at the same time was saying, hosted solutions and things that aren't actually deployed on premise, a lot of those should already be in compliance. There's solutions available. There's, VoIP positioning providers that can provide 911. So there are solutions available to the hosted provider that are easier to implement. And so while it's not clear, it seems that their intent is, a system that's installed, deployed at a customer's premise that is a legacy hardware or software.
Gotcha.
Hosted, it's a little bit less clear.
Okay. So if I was being as pragmatic as possible here, or as trying to be as safe as possible, better said, as a hosted provider, I can just go ahead and assume I have no grandfather clauses. I need to be, anything that I have done previously or can do in the future should be compliant, period. Because as a hosted provider, we don't have those, right? We don't have those, that February 15th date.
Right. And again, because the grandfathering applies to multi-line telephone systems. Now, again, a voice over IP solution may fall under the definition of multi-line telephone system, and so there's some gray area there. But the FCC's discussion was in the context of multi-line telephone systems. When it switched to its expanding these requirements to voice over IP, it did not grandfather existing voice over IP solutions, unless you could argue that they're an MLTS and therefore don't have to comply. The intent was to provide flexibility. The underlying spirit of the FCC's rules is that over time, customers will upgrade and replace systems service providers will upgrade and replace their infrastructure and their systems and their hosted platforms in order to come into compliance with these requirements. And by the way, they've had sufficient notice. So clearly the FCC's underlying goal is that over time everything will comply, and that they've implemented a grandfathering for certain kinds of systems and certain kinds of deployments in order to address the specific unique circumstances of those systems.
I apologize if you've addressed this in a future slide. I looked through quickly. I didn't see it addressed, but there are other compliance requirements, other entities, like I'll use HIPAA, for example, with medical. HIPAA, there are allowances for if you know yourself not to be in compliant, but you can show that you're actively working towards that to make those meaningful changes. You can, usually there's some breathing room there. Are those in effect at all, or is this, if you weren't there by February 16th, you're out of compliance, period? I'm looking for the penalty side of it, right? The stick side of it.
Exactly. Yep. And so there isn't the FCC set up a complaint process so that it envisions becoming aware of a situation through a complaint or some other inquiry to the FCC that says this company is not compliant, or that company isn't in full compliance and here's why. So there isn't like there are for some other FCC requirements, an annual certification that a company tells the FCC, I am in compliance with X, Y, and Z, and it's signed by an officer. There isn't that kind of a compliance here. So where it will come up is a system fails and there's a lawsuit of some sort, and then a company is found to be liable because it wasn't in compliance. There is a limitation of liability that extends to companies under Kari's law and also under the Net 911 Act. But again, if a company is not in compliance, then a plaintiff can argue that they're grossly negligent or willful misconduct. So it'll come up in that context, and in the event of a complaint from a customer or a partner or a competitor that a system is not in compliance, and the FCC investigates and determines that the company is not in compliance, and then it would fall into its normal enforcement process. So there isn't a certification type of filing or anything that would trigger a recognition of non-compliance. It's more of a third party comes in and identifies it.
Okay.
So I want to just briefly touch on addresses kind of the issue that companies do think about with legacy systems, and that is that the FCC said anything that's legacy doesn't have to comply unless if it can't do so without substantial modification. And of course, the FCC chose not to define what a substantial modification is. It kind of said, here's the things we think it's not, and here's the way we think what might be. So things like improvement to the hardware or software of the system, upgrades to the core system, or substantial upgrades to the software, or any software upgrades require any significant purchase. Again, it didn't say what that means, but what's significant for one company may be not significant for another. And so there is can a system be upgraded? No, here's why, here's what it would cost. And that's substantial from our standpoint, and so we're not making the upgrade. The other place that this might come in is on the FCC. So at the other end, the FCC said that minor changes, adding lines or extensions, is not significant. So somewhere in between those two is a broad range of what might trigger compliance, and that's really it's what kinds of changes for my legacy system might suddenly make it have to comply with both Kari's law and BAUM'S Act. If I do a software upgrade, or I deploy to customers software upgrades that do other things and add other capability and other functions to my solution, is that a significant upgrade that now subjects my legacy system to the full gamut of requirements? So again, I hate to say every single instance, but when a company is doing an upgrade to its legacy systems or is deploying software updates to customers, it needs to look carefully to see whether those are substantial of a type that would somehow convert the legacy system to now have to be into compliance.
I wonder, if they considered any kind of negative impact this may imposed, because there's plenty of I could argue free PBX 3CX, there's on-premise SIP PBXs, right, that you need to do software updates to keep them safe from hacking and from any kind of fraud and other stuff. So they have very frequent maintenance schedules. Free PBX releases micro updates regularly. But I could see here, then you start talking about substantial modification, doing a minor upgrade to prevent a risk of hacking, but now you're opening yourself up to, you've made a substantial modification. Am I at risk for this? I wonder if the FCC considered the negative impacts of people willfully withholding these upgrades, so that just to hold on to a little more time, right? And the risk that presents to people that get affected by fraud and hacking and everything else.
Yeah, I think a security upgrade probably would not be, in order to keep the system free from hacking or from fraud, would not necessarily be the kind of upgrade that would trigger compliance. But if that's included in a software upgrade that, like I said, adds additional functionality or adds other features, or is a core update of the software, then maybe it's now moving into the area where it's a substantial of enough modification that it triggers full compliance. And so that's the kind of thing that companies can be thinking about as they're developing upgrades or updates to platforms or to solutions. Is this going to now bring my system into compliance? And if so, what do I need to do to make sure that I'm in compliance going forward? And especially with the dispatchable location date coming up in literally a few days.
Yeah, I know you have quite a few slides, so we'll withhold any other questions till later. Simon will put up the link for the presentation download as well, and we will provide contact information for the CommLaw group for both Michael and Chris. But yeah, I want to give you time to get through this in the next 20 minutes or so.
Sure.
Great. Well, thank you, Ray and Michael. Now we're moving on to BAUM'S Act. And unlike Kari's Law, which had obligations in the statute, BAUM'S didn't itself impose new 911 requirements. So all of this confusion that's about to follow is to be blamed on the FCC. The Act required the FCC to conclude a proceeding to consider adopting rules to ensure that dispatchable location information is conveyed with a 911 call, regardless of the technological platform used, including MLTS, and MLTS is defined the same way as it is under Kari's Law. So these multi-line systems are now brought into this dispatchable location world. The FCC has had 911 rules of some stripe or other for around 2 decades, and for interconnected voice over IP since 2005, two-way interconnected VoIP has been required to allow them to transmit 911 calls and the user's registered location to the applicable PSAP. They're required to obtain registered location, the physical location of service from each customer, and provide customers with means of updating the registered location, including at least one that requires just the CPE. What BAUM'S Act is going to add to that is that dispatchable location information be transmitted to the PSAP as well. And that means the street address of the calling party as validated, and additional information like room number or floor number or similar information that's necessary to adequately identify the location of the calling party. The goal being to enable first responders to quickly locate the caller. Now, what is sufficient to identify is something that's not really elaborated on in the rules, but floor number, and all of that, definitely. Where MLTS is concerned, the BAUM'S Act rules apply to the same categories of MLTS participants as Kari's Law does. So you have the manufacturers, importers, sellers, lessors on one side who have to have this pre-configured product that is going to be able, if properly installed, to convey dispatchable location information. And then you also have the parties who are installing, managing, and operating, who then must as they install and operate it, must make sure that on the front end that the system will be able to convey dispatchable location information automatically to the PSAP. And street address is required to be validated. The FCC mentioned that there are a number of databases against which to do that. So that is a requirement. Okay. In addition to the MLTS providers who were subject to Kari's law, the BAUM'S dispatchable location information requirements are going to apply to fixed telephony, Plano telephone service, and voice over IP providers, including for the first time, one-way outbound voice over IP. They also apply to TRS providers. There will be some applicability to text to 911 and wireless, but that's not really in the same regime. There's more of a best available technology standard, and that itself isn't until January 6, 2022. So really, it's MLTS who have to worry most now.
Or have they considered at all making these requirements for? Because I know some departments are allowing texting 911 now. Have they gotten into that at all? Great.
Not yet. Thank God, you don't have to worry about that in 6 days.
I will point out that the FCC recently requested comments on it implemented 988 as a national suicide hotline number, and it just requested comments on whether it should also require that calls to those numbers include dispatchable location. So the FCC has teed up, if you will, the expanding this dispatchable location concept to another type of calls.
Wow. Okay.
Yeah. Now, one theme that's going to repeat through here is the FCC did notice in its comments, it did pay enough attention to folks to recognize that there's a significant distinction in the capabilities between the MLTS end user device, depending on whether it is fixed or whether it's, mobile or portable, and whether or not it's used on the enterprise's premises or whether it can be, picked up and taken to any remote location. And so there's a divide in the requirements, including the effective date, based upon this fixed non-fixed distinction. A fixed MLTS device is that is connected to a single endpoint and that cannot be moved by the user without the help of an installer or a network manager or an IT person. So think, in terms of a desk phone that is hardwired in there. And what the FCC found in looking at that is that it is readily achievable for fixed MLTS devices to be able to transmit dispatchable location information automatically with a 911 call. They found that you can rely on the enterprise at the time of installation to actually provide the location information of where this phone is sitting to be automatically then conveyed to the PSAP when a 911 call is made from that device. And believing that that is absolutely feasible and something they can do, the effective date of that is January 6, 2021.
Wow. Okay.
Yeah. Non-fixed devices, however, so think in terms of soft phones or think of, any, a laptop, some device that can be readily moved by the end user without involving the IT guy or calling in the manager or installer. The FCC recognized that it's going to be a lot more difficult for those types of devices, even within the enterprise's own building or campus. So first of all, it put off the compliance date by a year to January 6, 2022. And it also allows for some alternatives to dispatchable location information. So you can get a manually updated user address that's, akin to the registered location. requirement in the VoIP world. Or you can use alternative location information. And alternate location information is defined as information that identifies the caller's civic address and approximate in-building location. It can be coordinate-based. Generally in larger buildings, you would want to include the floor level or approximate floor location, such as a building quadrant. But you have different options for these non-fixed devices. And if that non-fixed device is a remote one, it is taken off of the campus or out of the building, those are even slightly more flexible. Again, if they can do dispatchable location information, that's the gold standard. If it's technically feasible, you want to do it. Otherwise, they can provide manually updated user information or enhanced location information, which is pretty much just the best that's available that can be obtained in a technically and economically feasible manner at a reasonable cost.
So I see questions here real quick, and I think you just addressed this. For those that take their physical phone from the office to the house, does that count as fixed, or would that be not fixed?
Well, if you can pick it up and take it, it's non-fixed.
Okay.
The idea is that the fixed device is going to take, the user's just not going to pick it up and be able to plug it in anywhere and work. That's going to be their desk phone or something that is tied in at an on-site location. So if you're using non-fixed devices, ones that, a soft phone that can be moved from your desk to the conference room, or one, what would then be considered a remote device if you can take it off premises, you do have a little more time to make sure that you'll be able to provide some form of location information that'll comply with the rules. Okay, looks like we got another question here.
Yeah, so I see, Alan asking also, soft phone apps, right? The non-fixed, the 2022 date. Not all of them have those technologies available, but you're saying even in 2022, it's still a best effort type?
It's going to be, there's like a tier of compliance. Your best, your gold star is dispatchable location information as they've defined, where, you've got the validated street address and the in-building location. And if you can do that, great. If not, for these folks, you can have a system whereby the user, when they move the device, is prompted to manually update their location, similar to the way VoIP's been required to do for registered location. And you can also have what the FCC is calling alternate location information, which is, say something similar to the XYZ coordinates that wireless carriers have to do, where it's, okay, these are the coordinates of the building and rough height in it, civic address and floor. So there is going to be some flexibility in how you comply if you have a portable device.
I see Keith saying virtually all VoIP phones are not fixed. They use IP to connect, making them non-fixed. I wish it was as easy as that. I would love to.
It would be nice. It really is a question. Yeah.
Sorry. I mean, I could see the argument. It's installed at one location. It's been there for a year, and then you take it home. It would have fallen under the category of fixed based on the history of it. I could see arguments on both sides. That, just be cautious. I mean, at the end of the day, that's all you really can do, right?
And your argument there is going to be, if this user was able to simply unplug it and take it home on their own without involving the service provider, without provide, that it was indeed all along a non-fixed device.
Are you seeing more service providers, because you represent so many service providers, are you seeing them come to you and say, we need disclaimers. We need lots of disclaimers. You know, is there any protection there? I mean, is this something that can even be, putting the onus on the end user, saying, we provide the functionality for you to manually update yourself. You have to take the responsibility. But from what I'm seeing here, the FCC doesn't really care. It's still on the service provider, right?
Well, a lot of that too is going to circle back to some of what Michael discussed before, is who is the operator at this moment and who is the manager? What roles do you have defined? And while your contracts aren't going to be dispositive, the FCC can and will look at them in the event of a complaint. So to the extent that this customer is going to want the flexibility to do things without coming back to you, you are not managing the system for them on a day-to-day basis, you can put contractually more of that liability onto the customer. And I think it's fair to do so with a lot of enterprises, that they're going to be the ones doing it. So they need to either keep you in the loop, or they need to, you can have indemnifications. There's a lot of ways to attack that from the contractual standpoint. Fixed telephony folks also are required to give dispatchable location come January 6th. That's plain old telephone service. As far as the FCC is concerned, they've already been doing that, and they better have already been doing that. So for fixed VoIP, and right now for the moment, we're talking about traditional interconnected VoIP, the two-way interconnected folks. As of January 6, 2021, will be required to provide automated dispatchable location information with the 911 call. Now, that may be information that was obtained by means of the registered location. So when you go and install the system, and these are fixed devices, these are desk phones that the customer can't just pick up and walk around with, and they enter that initial registered location information, that information, as long as it otherwise complies, it has the street address that you can validate, has the approximate in-building has the in-building location, that will qualify. You just have to be able to dispatch to the PSAP automatically without further action on the part of a customer at the time that the 911 call is made. And again, back to non-fixed services, and this is going to be a lot of VoIP folks. That's going to be your soft phones and your computer-based systems, your laptop-based calling. You have an additional year. You have several methods of doing it. If you can get automatic dispatchable location information from the device that can be conveyed to the PSAP, that's the gold standard. If you can't, you can have the requirement of the user automatically updating their registered location every time they move. You can use alternate location data, including coordinate-based data. And in the absolute last resort, if you just can't get location information to convey this to the proper PSAP in any other way, as long as you've used a good faith effort, you can still route 911 calls to the National Emergency Call Center so that the operator can communicate with the customer to get their location. But that again is the last okay. And for the longest time, there was the so-called Skype exception, that if you were really only doing one-way inbound calling or one-way outbound calling, you were not considered interconnected voice over IP and not subject to a whole host of the FCC's rules, including 911 obligations. Under the new implementation of BAUM'S Act, the FCC has brought outbound one-way VoIP into the definition of interconnected VoIP for 911 purposes. They understand that this is new, so if you are outbound one-way only, you get an extra year to comply. But again, when that year is up, you need to be able to provide dispatchable location information if it's technically feasible, or otherwise allow for manual updating by the user of a registered location, or provide alternate location information. And again, that includes coordinate-based information.
I just want to add also that while we're talking about BAUM'S Act and dispatchable location, by that January 2022 date, one-way outbound only have to comply with all the other 911 obligations. Contracts provide disclosures to customers about the limitations of the system. They have conspicuous identification of those limitations to customers if they route called appropriately. So essentially all of the 911 rules, in addition to dispatchable location, will apply to outbound only. And the FCC has also considered expanding other requirements to outbound only voice over IP, including truth in billing and some others. So there may be additional changes coming for these types of offers in the near future.
Right, the new 988 calls another.
And I see something here from Alan, hosted PBX may be a customer obligation to define whether their endpoint is fixed or mobile. I don't really think it's up to them to decide, is it? I mean, those definitions have been placed, definitions-ish.
Yeah, exactly. The FCC has given it that line as the one, whether or not it can be moved by the end user without further assistance. But certainly at the time of installation, that is a good time to identify what these customer devices are. And again, two-way VoIP has been required to have all sorts of 911 disclosures for years now. One-way will be required to do that as well. One of the ways you can make sure you're dealing with this is to include in your contracts and in your disclosure documents the requirement that, we're identifying what these devices are. And this is what's going to comply, and you don't move this fixed device without notifying us. And you can definitely put a lot of the onus back on the enterprise to make sure that they're at least not hindering your compliance.
Right. I mean, and for all intents and purposes, a lot of it, like you said, POTS have been doing this for a long, long time. We've had our E911 registration. It's not too much that's an additional burden, I think, for the hosted providers. I think the on-premise PBXs are going to have a little harder time. Worst case scenario, we have more numbers to register, so we have more specific locations. But it doesn't seem too onerous, I think. I'm completely open to other opinions, but it's it doesn't seem too bad yet. But with that, Michael, Christine, I want to thank you. We definitely appreciate your time. Like I said, they are the resource for service providers. Do you guys work with PBX installers and those people too, or is it specifically service providers?
Yes. So, and we have clients who are installers. We have clients who are resellers. We have clients that have that design and deploy and have partners and distribution networks. And so, our clients fall into all different parts of the supply chain, if you will, cloud-based, premise-based. So we cover all variety of different kinds of voice over IP or other advanced communication solutions. And this is an issue that's come up quite a bit, actually, over the last year for a number of different kinds of providers. And again, especially if a company is dealing with multiple entities and fits into different roles within the deployment system. And, what are my obligations in scenario A? What are they in scenario B? So.
Yeah, and that's why, we make our partners available to our clients. I don't know how anybody can be, one of the things I talk to potential partners when signing up with us or looking to get into telco is it's truly an ecosystem thing. Don't just look at being able to provide the system and the service, but all the ancillary stuff, right? The logistics, the billing, the administration, and the liability, the risk, the compliance, the remittance, the registration, and keeping track of all the changes. And that's why you need to have the CommLaw group. It doesn't matter. Don't go into this on your own thinking you're going to Google some docs and think you know what you're doing.
Right.
If there's anything I've learned in working with you guys and my time in the industry is anything I know is absolutely invalid in 30 days. So, just keep it to the professionals. With that,
Right.
Christine, Michael, I definitely appreciate you guys. Thank you so much. Their information's up here. Those of you that are on the webinar, may not have gotten a chance to watch the whole thing. It is absolutely recorded. It will be available right after we finish this on YouTube and Facebook. I'm sure we will be updating this, do a recap or an update webinar on this within the next 12 months. I'm very tentatively cautious about the changes to SMS, possibly adding E911 to SMS, because that seems like a whole ball of wax on its own, not to use a different term. But thank you so much for your time, guys. We appreciate you. Have a great rest of your day and a happy new year.
Thank you. You do the same. We appreciate the opportunity, and happy new year to you and to everyone who's watching.
Absolutely. So, and we're going to Simon's going to go ahead and bring up our upcoming events. I do want to answer real quick. Michael Sullivan's asking, what's OIT doing to implement Kari's law? We are going to put out a notice before the January deadline. We're going to put a notice out of the available changes, but we do have those notifications in place, email and voice calls. There will be some changes to, I won't get into pricing on the call, but there will be some changes to your pricing for 9/11 to better facilitate, because you're going to have some burden, right? We have the fields available so that you can add field floor, building, apartment number, a room number. We have those fields available in the 9/11 integration today. Realistically, you're going to have to do some more registration, more E911 numbers. So we're going to help you guys out that on the MSA and the pricing side. The documentation will be available for the notification side as well, so you guys can go ahead and enable that. And there's some other things that are going to be posted out in Partner Central. So we will keep all of that information available to you guys. And we'll give you best practices for updating this as well. If you have any questions, you know how to reach us. We're always available either on the Discord server or email or phone call, and we're here to assist you. As far as upcoming events, we have tomorrow the Tech Bar, our New Year's Eve special. We don't have any special guests. We have all the special guests. We're bringing back up old friends and acquaintances. We did a call for toasts and for New Year's resolutions, and we have tons of those videos we're going to share and some other good stuff. Don't forget we're launching our Sweat into the MSPs, presented by OITVOIP and Lifecycle Insight, some awesome partners. Same group that brought you the MSP Halloween, MSP Trick or Treat. That's going to launch January 1st with lots of good goodies. We have our Partner First webinar coming up on January 7th. It's crazy seeing 2021 there with DNS filter, blocking malicious content with work from home professionals. There's so many of us that are now working from home or working from anywhere. If you saw my 7-figure MSP webinar, this is how you protect them. Speaking of 7-figure MSP, January 11th on the Tech Bar, Lisa Compton of 7-figure MSP, Miss Purple Hair herself, although every time I talk to her, the hair is a different color and she's got a different background. So let's see what she has for us on January 11th. January 20th, the Partner First webinar with Dave Sobel of MSP Radio. We do a lot of webinars. I talk a lot about, anybody who knows me knows I love my cameras. I love my videos, my toys. We're going to make sure you don't look like this on any of your webinars. We want you to look nice and pretty, maybe a little more pretty than this. We'll talk about getting your best foot forward, your best image and audio for those webinars. And don't forget our NFL Pick'em League, go.oit.co/NFL 2020. There's still a few weeks left. See if you can topple Keith and Sean. I know Keith's still at the top of that. Keith and Sean still battle for the top of that list. Guys, thank you so much. We appreciate you. Look forward to seeing you tomorrow night. And if I don't see you, have a happy and wonderful new year.